Hi, I'm Tom Marks with the Marks Law Firm, and welcome to the Healthy Family Law Attorney. Today we have a special guest with us, and we're going to talk about bankruptcy tips for your family because we believe your family matters, and we want to provide hope and help to your family to navigate successfully the family law process in a healthy way. So today we have Anne Marie Bowen. She is a bankruptcy attorney and she helps people resolve their financial problems. She has been practicing in Central Florida for over 20 years. She is the former president of the Central Florida Bankruptcy Law Association and is also the past chairman of the Bankruptcy Committee for the Orange County Bar Association. She's an author of two books. Her most recent book, Forgive Us Our Debts, When It Is Okay for Christians to File for Bankruptcy. Anne Marie, how are you? Welcome aboard.
I'm great. Thank you so much for having me today, Tom. I really appreciate it.
I'm thrilled to have you on board because bankruptcy is an issue that we deal with in family law more often than you might think, that our audience might think. Obviously, divorce is not a good financial option. It's obviously sometimes necessary, and but it creates some issues financially. So we brought you on board,
Right.
Anne-Marie. I want to
Mhm.
ask you, when is it that families or individuals should be considering bankruptcy?
That's a great question, Tom. A lot of times people they have financial problems, and sometimes people, if they're paying their bare minimum payments, they feel like they're okay, but then there's an interruption in the paycheck. Something happens. In with your family law process, what's going on is you have a lot of times two people earning income and one household, and then what happens when they're separating, right?
Right,
We've got two households but one income of each. And so a lot of times people just can't make it. They can't take care of all those bills. And so then that's a time when they need to be considering what could they do, and is bankruptcy something they should be thinking about when they have a whole lot of debt.
right.
Mhm.
And so when I get a new client in, obviously I'm going to advise them about financial issues as well as the kids' issues, child support, alimony, but there's also equitable distribution. And so we fill out what's known as a financial affidavit. I
Mhm.
did a prior video on the financial affidavit is the most important financial document in the entire case. And so in that document, that's where they list their income, gross and net, all of their expenses to see if they're spending more than they're actually making. And then you look at their assets and their debts, and oftentimes their debts far exceed their assets. So I'm looking at it and going, wow, this financial affidavit says there's a financial problem here, and bankruptcy may be a solution, not always. So would you tell our audience when they might consider bankruptcy before a divorce, maybe during a divorce, or perhaps even after a divorce?
That's really a key consideration for people to think about. It's really interesting on your financial affidavit. Those are the exact same things that we have to look at in bankruptcy. What's your income and your expenses? What are your assets? What are your debts? So we look at the same exact things, and it's really important. If there's a potential there might be a bankruptcy, you might want to look at it together with your family law attorney and perhaps bankruptcy attorney. But sometimes it's really better to file bankruptcy before the divorce goes through. When you're still married to your spouse, even if you live in separate households or you live together, one spouse can file bankruptcy alone while they're still married, or they could file together. And if they file together before a divorce is final, they're still legally married. They're allowed to file together, but sometimes it's not a really good idea.
Right.
So,
Yeah. And one of my concerns as a family law attorney is if the other spouse, not my client, let's say, the other spouse files for bankruptcy, that it doesn't matter that the state court judge is going to give those debts to the other spouse because the third party creditors can still come after my client if it's a joint debt, right? So the
That's exactly right.
bankruptcy of the other spouse could create significant issues for my client. Can you talk about that a little bit?
That's exactly right. Because what happens, a lot of times people think in divorce, even if there's no bankruptcy at all, but they think, okay, the judge said that, my soon to be ex-husband is going to pay our joint MasterCard bill and to the tune of $10,000. Well, that's great for the family law judge to say that, but you know what? The creditor, like you said, the creditor, Bank of America or whoever, Bank of, they didn't agree to that. And if you are jointly liable, you're both 100% liable. I think that's one of the big myths that people get confused. They think, well, if the family law judge said, I don't have to pay it, he has to pay it, that there's
Exactly.
no agreement with the actual creditor who you borrow the money from. And
Right. So,
mhm,
right, it's like a two-step process. One, the creditor has the right to come after both joint debt obligors, and the
right,
family law court is a state court that doesn't impact that. The
right,
order only affects the two parties in the divorce, not the third party creditor. So
exactly.
tell our audience, what is the difference between a state court family law judge and a federal court bankruptcy judge?
Right. So the family law process happens in the state court system. And with bankruptcy is a federal law. So we're in the federal court system. So we're really in two separate, completely separate divisions of the law of how, justice is going to be divvied up, completely separate systems. And so just because the family law judge says one way doesn't mean the bankruptcy judge is going to say another way. On the other hand, bankruptcy judges they are very good about respecting a prior court order. But a lot of times with family law, the issues may not be resolved before you get to bankruptcy, one or both parties get to bankruptcy. So let's get back to that and talk about sometimes when, a parties would maybe, want to file bankruptcy um, before bankruptcy,
Hmm.
before the divorce is finalized. So
Right.
a time that when that might be is, let's say that the parties have some assets and they own the house, that the marital family home, and then they also own, say, a rental property. So if you have where only one spouse files bankruptcy, they're still married, there is a chance to protect both homes. Whereas if the divorce is already final, person can only have one homestead. You can only protect one of those two houses. And so that might be a good example of when maybe you should consider, maybe one spouse wants to file while they're still married. So that's, a good example of that.
Right. And, for me, as a family law practitioner, if the parties have already seen a bankruptcy attorney before they come to see me, and those issues, maybe they've already gone through the bankruptcy process, received a discharge, then I know what debts I'm dealing with. If they
Hmm. Right.
don't file before and they file in the middle of the divorce, it can create a whole host of issues, and there might be a stay, and I'm going to have to work with a bankruptcy attorney, and obviously Anne Marie, I can call her, and has the experience to tell me how to navigate the bankruptcy, the federal process, while I'm going through the state process. But also, when I'm thinking about a case and how we're going in the equitable distribution worksheet, part of the marital settlement agreement that says, okay, who's going to take what assets and who's going to take what debts, I'm a little concerned sometimes when the other spouse wants to take all of the assets and they say, well, I'll take all the debts too, to kind of equalize it. Well, what happens if they take all the assets and then they file for divorce and they wipe out all the debts and they were joint, and then the creditors come against my client? Have you ever seen that, Anne Marie?
That's a really great consideration to think about, is that maybe one of the spouses doesn't want to just give up all the assets. They probably want to keep their half, keep whatever they're entitled to. But that's sometimes, a couple might want to file bankruptcy in the middle of the divorce process, because if they could both eliminate all the debt, or not all of it, but most of the debt, that would be really helpful. That would make the divorce a lot cleaner. And it would, if the debt is eliminated, most of the debt, not all debt's always going to go away, and it depends. But Tom, I can give you a good example when maybe a couple would not want to file bankruptcy
Okay.
before the divorce is done. And that would be if the couple needs to do a Chapter 13, a repayment plan that's going to last them for 5 years. I don't think, I generally don't recommend that a couple would file a Chapter 13 together knowing they're about to go be divorced, because you have to rely on the other spouse to make their half of the payment that's due
Right.
each month to the court. That's just not a good situation. It's hard enough being joined when there's children involved, right, for the next 18 plus years, right, the rest of their lives. But
Right.
to be joined with debt for 5 years for someone that you're not necessarily so happy with and that you can
Yeah.
depend on is probably not a good idea.
Right. Of course.
Yeah,
Right.
yeah. Mhm.
That's interesting. It makes me think of when you're talking to clients, potential bankruptcy clients, about, they're concerned about, okay, what kind of stuff can I keep? What kind of stuff am I going to lose in the bankruptcy filing? Is there some? I think they're called exemptions. What
Right.
what do you advise the clients there?
Right, yeah. And that's true. A lot of people are concerned about that. Some people have the thought that, oh my goodness, if I file bankruptcy, I'm going to lose everything I own. And maybe I don't own much, but it's a lot to me and I don't want to lose it. And so
Right.
you're right. There's the things that the law has called exemptions. So exemptions are the law that says, what do you get to keep? Okay. When you file bankruptcy, all your property goes into this fictional thing called the bankruptcy estate. And
Hmm.
so whatever you own goes in there, your house, your car, your clothing, your bank accounts, your IRA, everything you own goes into this big thing called the bankruptcy estate. But then the exemptions is what lets you take things out of the pot. And by taking them out, they're not available for creditors to take. Okay,
Okay.
so that's what an exemption is. And what we're talking about is, what do you get to keep when you
Yeah.
file
What do you
bankruptcy?
get to keep?
Yeah. So everybody can have one homestead. So let's say you own the house that you live in, you sleep there, your driver's license is there, your car is ready. That's where you register a vote there. Okay. Your home is your homestead. You can protect it from all creditors except for those that you gave a lien on. So the mortgage, if you don't pay your mortgage, the bank's going to take the house.
That's
But
true.
Visa or MasterCard, they can't make you sell the house to get your equity out to pay them. So your homestead is exempt. In general, most of your, generally your equity is exempt, whatever you have. So people can't take your home. There's exceptions to every rule and things like that. But in
Sure.
general, people in
Right.
Florida, you're keeping your house.
Okay.
Cars, okay? Each person can have $1,000 equity in one car. So $1,000, that's it.
Wow. It's
So
not much.
it's not much, but let's say you lease your car. Well, if you lease your car, you don't own it. Okay. You have the right to drive it around as long as you make the payments. So you're not going to lose a leased car as long as you keep the payments. A
Right.
lot of people are driving around, newer cars. Been a lot of good deals this year, right? So people are
Right.
driving newer cars. There's not a lot of equity, if any.
Right.
But if you do have equity, there's ways that we can address that. So that's $1,000 equity. You get to keep cash value of life insurance. You get to keep $1,000 worth of personal property, furniture, clothing, jewelry, money in the bank. So there's a lot of things you get to keep. If you do not own a home, then you get an extra, what's called a wild card exemption. So you get extra $4,000 worth of stuff. So let's say you don't own a home, but you've got a
Right.
car that's worth 5,000 equity, you're keeping your car. So
Okay. So a renter gets to keep more of their car. An
yeah,
extra four, so it's 5,000 in the
5,000
car.
total, right? And which could be used towards anything. So let's talk about the married situation. So
Okay.
if you are married, you're still legally married. You may be living apart. You may be throwing daggers at each other. You may be going through the divorce process, right?
Right.
And hammering out everything, whether it's a amicable divorce or maybe not so friendly. If you're still married, then anything that you own jointly with your spouse, as long as there's no joint unsecured debt, meaning things like Visa, MasterCard, unsecured loans, things that aren't secured by property like your house or your car or a boat, for instance. If you have joint assets and you're still legally married and only one spouse files bankruptcy, they can protect all that joint property. So that's what I said in that example before, where the couple, maybe they own the house they've lived in for the marriage, and there's another rental home they own, or two, or second home, or they
Right.
own, they own their cars are jointly owned together. Maybe they've got a nice Mercedes and it's paid for. Well, if it's the title is still joint because the divorce hasn't gone through, okay, they can protect that nice, $20,000, $30,000 car. They can
Okay.
protect
That's
it.
good to know.
Bank accounts would be
Okay.
protected. So that's a reason to think about, maybe you want to file bankruptcy while you're still legally married.
Okay. Bank accounts that are jointly titled.
Exactly.
Right. What about retirement plans, IRAs, 401ks, that kind of thing?
Yes, IRAs, 401ks, 403bs, all of those retire in the state of Florida, and that's what we're talking about here, state of Florida.
Right.
Wow, all of that stuff is protected. So if you've got $1 in your IRA, or you've got, $1 million in your IRA, if that's something you've been saving over time and building up, that's yours to keep. There is a law, you're going to keep your retirement funds. So that's an
Okay.
awesome thing that you can keep that. Yes.
Yeah, because I know there's a state law with exemptions also. And does the
Right.
bankruptcy court follow the state law exemptions?
Yes. So there are federal bankruptcy exemptions, and then there are state laws. Florida has opted out of the federal exemptions, but sometimes, right, but sometimes a person who might file bankruptcy in Florida has to use them. And that's if you haven't lived in the state of Florida for essentially 2 years before you file bankruptcy, we have to go and look to the prior state. You may not qualify there. You might be left with the federal exemption. So kind of getting into the weeds a little bit, but it
Okay.
depends on, the length of time you've been here in Florida. Mhm.
That's interesting. I know we're getting into the weeds a little bit, but that's just another difference between federal court and state court, because you've got a 2-year residency requirement in that federal court situation, whereas in Florida, you just have to be a resident for 6 months prior to filing for the divorce here. So it's only a
Well,
6 month.
let me clarify that. So you can file bankruptcy in Florida. So we're talking about two different things. Is one is the exemption law that applies to you. You have to be here for 2 years, but you can still file bankruptcy in Florida. You can file bankruptcy anywhere where you've lived the greater part of the last 180 days.
Oh,
So
wow.
180 days is 6 months. So the greater part would be basically, 3 months and a day. Then you
Wow.
have then the venue is proper where you live if you've lived there for 3 months and a day. And
Okay.
so that could be somebody that moved in from Georgia to Florida, or it could be somebody who moved from Miami to Orlando. Wherever you live. So let's say you moved from Georgia, but you've only been here for 2 months. Well, if you want to still file in Georgia, you can file bankruptcy in Georgia if that's to your benefit.
Okay.
Mhm.
Or
Yeah.
interesting. So
Yeah.
before you mentioned a Chapter 13 bankruptcy. Can you tell our viewers what are the types of bankruptcy filings they might look at if they came to see a bankruptcy attorney?
Sure. So for most individuals and families, they're going to look at a Chapter 7 or Chapter 13, but there's also a Chapter 11 and 12 that doesn't apply to most individuals. Chapter 12, that's for family farmers and fishermen. And you know how many we have here in Central Florida? Not many. So Chapter 12, don't need to worry about that. Chapter 11, that's usually a corporation trying to stay in business, but it's sometimes an individual. There are different circumstances. Somebody maybe owns a business, even if it's a small business. Sometimes they might want to look into a Chapter 11. But for the most part, our families going through divorce or having been divorced are going to look at Chapter 7 or 13. Chapter 7, that's the one that's called a liquidation, where you basically try to erase most of your debt and wipe it away and start over. And that's called a discharge, when you can erase that debt. Chapter 7, you're in and out of bankruptcy within 4 to 6 months. The Chapter 13, that's the one, it's a repayment plan. It's for wage earners, but you can have source of income from any source, such as if you have child support income, that's income. Alimony, that's income. So in a Chapter 13, you're repaying what you can afford of your debt. And some people think, oh my goodness, I owe $50,000 in credit cards. I could never repay that. Well, you don't have to pay the full amount in a bankruptcy repayment plan. You have to pay what you can afford over the next 3 to 5 year period, depending on your situation. So payments can be very affordable. And for some people, that's a great way to take care of what they owe.
Well, and I'm sure that if somebody comes in your office, you can get a lot more granular, get a lot more into their specific situation and
Sure.
needs. Well, let me ask you, are
Mhm.
there any other options for people other than filing Chapter 7 or Chapter 13 bankruptcy?
Sure. Sometimes we get people, they just are not ready to file. They don't want to file. They have some conviction against it, or maybe they're not ready. But yet the creditors are knocking on the door. Literally, sometimes it's the sheriff knocking on the door with a lawsuit. That's
Right,
usually a big clue that you really need to file. But for a lot of people, they're just not ready. And so there are other things. And sometimes there's a great option. One thing we do is creditor negotiations. So let's say you owe, a lot of debt, unsecured loans, credit cards. You've got debt you just couldn't pay in full, but maybe you've got a relative, a family member, a friend, somebody that's willing to help you out. And they may say, look, I don't want you to file bankruptcy. I'll help you. So if you've got somebody or maybe even you want to take money out of your, a life insurance cash value or something. You want to take money from somewhere and you want to try to resolve your debt without paying it all, we can negotiate with them. A lot of times, credit cards, we could settle them. We negotiate with the creditors directly to say, here's your situation, here's the hardship. You used to have two incomes, now there's just one, and you can't afford to make those payments, but here's what you can do. You'd like to make an offer to settle by paying, a certain percentage of it. And we've been very successful with that, helping people to negotiate and stay out. Another thing is sometimes people want to go to something called credit counseling. And there are a few legitimate services that will not steal your money, but a lot of times you really have to be careful because there's a lot of, fraudsters out there just trying to prey on people who are trying to do the right thing, and yet they end up, you'll be paying $1,000 a month and it's their fee for the next first 11 to 12 months. So the people
right.
really have to be careful. They want to go to a nonprofit, 501(c)(3, like somebody that's really going to help you and not just take your money for their own fee. So you really want to be careful, but there are ways to resolve debt. But if someone's having struggles with it, you don't need to struggle alone. They really should contact a, bankruptcy attorney to see what can they do about it. And sometimes, Tom, the debt's just not that bad, but they don't know that because they feel like they're the only one and they think it's the end of the world. But debt is all relevant, to your situation.
Right. It's interesting. I think it's great that you provide alternatives, other options to your
Mhm.
clients other than bankruptcy. I
Sure.
think it's really great. It makes me wonder. I know, bankruptcies. There's a stigma attached to it. You don't want to say you filed bankruptcy. There's
Right.
also this thing you hear about bankruptcy follows you for a certain period of time. Is there a certain number of years that you either can't file bankruptcy again, or it's going to hurt your credit, or how does that work?
Yeah, yeah, sure. That's a great question. So bankruptcy shows on your credit report for 10 years. Okay, bad credit is only 7 years. Okay, so if you are, missing payments, each month X that your bad payment is showing up, bad history. So bankruptcy shows for 10 years, whereas just bad payments are only 7 years. But as a practical matter, after bankruptcy, people their credit gets cleaned up much quicker than if they just struggled along with debt for many years. It's going to go away because your debt to income ratio dramatically improves after a few months after bankruptcy, because it used to be maybe you had $100,000 in debt. Well, now you got zero in debt because you wiped it out in bankruptcy. So that's with the credit. Now, you had a question.
Well, that's good information. I mean,
Mhm.
I really like that. Um, it seems like there is hope. And
Oh, yes.
what would you say to our audience or somebody considering bankruptcy to let them know there's hope in the situation?
Well, there's always hope, because and everybody's situation is different, and you really just you need to not be ashamed enough to reach out and seek help. You are not the only person that's ever gone through this. You are not the only person that has ever, either maybe made some bad mistakes, foolish decisions, bought stuff you shouldn't have, or maybe just bad stuff happened to you. You lost your job. You couldn't help it.
Right.
You didn't do anything wrong, just your business couldn't afford you anymore. They got rid of you, or
Right.
your spouse didn't want to stay with you anymore. I mean, there's a lot of, you know, bad things happen to good people. And sometimes it's even harder for people to understand that maybe it's a combination, maybe some bad decisions and some bad luck. But it's okay. You're not alone. Don't feel like you're the only person. Reach out, get some help, figure out what's the best way to go. Somebody honest is going to direct you in a direction that's going to be best for you, for your personal situation. So don't hesitate to reach out. Don't beat yourself up. You are not a terrible person just because you got financial problems.
Right.
Okay? Don't beat
Right.
yourself up, and don't
There,
let anybody else beat you up either. Yeah.
right. There is
Mhm.
always hope. And that's
There is.
channel's about, to provide hope and help, which you're
Right.
doing right now. So, to wrap this up, I like to ask at the end of each interview, what is a healthy tip that you would give our audience? I have a blog called The Healthy Lawyer. This is the Healthy Family Law Attorney. So, what is a healthy tip you would give?
I would say, not to be afraid. You know, I don't know why it's just popped. Well, maybe because I see Jesus above your shoulder there, Tom. But think about, so many
Okay,
times. Yes, I mean, Jesus is right there carrying
we're
that
talking
cross.
hope, right? That's
Yeah,
good.
exactly, exactly. And it's like, be not afraid. How many times do you hear that in the Bible, right? Be not afraid.
Right,
And that applies to us in real life too. That people are scared, they are afraid, but there's so many resources out there, and there's professionals that can help, whatever the situation is. Don't go it alone. Don't be afraid. Seek out, get resources. There's a lot of help out there, and people can really, help you there's a light at the end of the tunnel. It's not a train, okay?
right. Okay,
Bankruptcy can
good,
it can
good.
seriously can provide such great relief, but sometimes people just are afraid to reach out. Don't be embarrassed, don't be ashamed. Reach out and get help. There's a lot of people that can help you. There's a lot of resources, but you want to talk to a professional. You are not alone, and you're not
Okay.
the only one.
Those are great tips. I think this has been great content. I mean, it's really given our audience some important information about
Right.
bankruptcy,
Hmm.
about how to avoid bankruptcy. There are other
Right.
options, there's hope, there's tips. So, I hope our audience has found value in this today. If you have, hit that subscribe button, hit that like button. If you want to hear future videos, I'm posting a new video interview every Friday and a new video on a legal topic every Wednesday. So, I just want to thank you, Anne-Marie, for coming on the channel today. I hope you've enjoyed it.
Thank you so much, Tom. I really appreciate you inviting me to help your listeners. And I'm so grateful to you for what you're doing. You really help your clients so much. I mean, you help them through the divorce process. It is not easy for a lot of people, just emotionally, just the legal issues, the financial, and you really help people. You've helped a lot of my clients. And I'm really grateful to you for taking care of people, just so well, legally, but also just emotionally, spiritually. You're the whole package, and I'm just really grateful to know you, and I just appreciate so much how you take care of people. So thank you for that, and thank you for letting me share with you today.
Well, Anne-Marie, thank you so much. I mean, we've known each other for a lot of years. I don't want to
Right.
say how many, because you're still looking young, unlike some of us. But over those years, you learn who you can refer to, who you can trust, because honestly, I know this is a little bit beyond the scope of our video today, but it's you have to trust the person you refer to. So I'm happy to refer bankruptcy to you because I know you're going to treat the client like a friend, like a family member. You're going to care about them. They're not just another number in the process. And that's important to me because that reflects back on me. I know you're the same way. It reflects on you,
Oh, yes.
who you refer to, because
Mhm.
if that person doesn't treat that client well, that'll get back to you, and there won't be any more referrals, and there shouldn't be.
Exactly.
So,
Mm-hmm.
because we both believe that families matter, people matter. So,
Exactly.
thank you for those kind words. I have
Oh,
enjoyed
thank you.
so much today. I'm just loving these interviews because, I've been practicing 35 years. So obviously I have built some solid relationships and with some high quality people, and it just makes this so much fun. So you are one of those high quality people,
Well,
Emery.
thank
Thank
you
you
so
so
much.
much. And
Thank
we
you.
are done for today. Thanks so much. We'll see you in the next video.
Thank you.